page. Six. Okay, the defendant counsel is absent. So there is proof of service at page 684 of the file. So the case is to proceed to judgment.
House court, please.
This is the judgment of the court.
House court, please.
From 15th April 2019, when the claimant took out a complaint against the defendants, parties continued amendments upon amendments up to 29th September 2023. By a motion filed on 15 July 2029, the defendants filed their memorandum of appearance and also filed statement of offense on 7th February 2020. By a motion filed on 23rd November 2020, the claimant filed his reply. The claimant again amended his complaint and statement of facts by a motion filed on 25th October 2021. Not done with amendments, the claimant again amended his complaint and statement of facts by a motion filed on 24 January 2022. The claimant again filed another motion on 14th March 2022 for amendment and filed clean copies on 7th April 2022. The defendant applied by a motion filed on 12th October 2022 to amend their statement of defense and another motion to substitute the witness statement on oath of Dauda Anjili with that of Eugenia Home on 29 September 2023. The claimant praised in his amended statement of facts for 5 reliefs as against the 10 reliefs sought in the amended complaint. The 10 reliefs sought in the amended complaint are as follows: a declaration that the claimant's appointment enjoys statutory flavor and therefore the claimant's appointment cannot be terminated without following the due process of law. 2, a declaration that the defendant did not follow due process of law before purporting to terminate the appointment of the claimant as conveyed in the letter of termination of appointment dated 5th February 2019.
Sorry, my lord.
Thank you. Okay.
Welcome.
So I take it again, 2, a declaration that the defendants did not follow the due process of law before purporting to terminate the appointment of the claimant as conveyed in the letter of termination of appointment dated 5th February 2019 with effective date of 24 January 2019, and consequently the purported termination is unconstitutional, ultra vires, null, void, and of no effect whatsoever. 3, a declaration that the purported letter of invitation to a meeting of officers committee dated 19th October 2018 served on the claimant during the pendency of criminal trial was maliciously and oppressively issued without justification against the claimant by the defendants, hence null, void, of no effect whatsoever, and amount to unfair labor practice which ought to be retracted by the defendant. 4. A declaration that the purported letter of termination of appointment dated 5th February 2019 served on the claimant's erstwhile counsel during the pendency of a criminal trial was maliciously and oppressively issued without justification against the claimant by the defendants, hence null, void, of no effect whatsoever, and amount to unfair labor practice and abuse of office, which ought to be retracted by the defendant. 5. An order compelling the defendants to forthwith retract the letter of termination of appointment dated the 5th February 2019, maliciously and oppressively issued and served on the claimant's erstwhile counsel during the pendency of criminal trial. 6. An order directing the defendants to pay the claimant's full salary and promotion arrears from September 2010 till date, estimated to be the sum of 80,978,405 naira 45 kobo only. 7. An order of this honorable court reinstating the claimant into the service of the defendants and payment of all the arrears of salary, allowances, bonuses from September 2010 till date. Particularized below, they are all particularized, amounting to 80,978,405 naira 45 kobo. 8. An order for the payment of the sum of 20 million naira only as general damages and or exemplary damages for the malicious and oppressive manner the defendants have used their offices to victimize and oppress the claimant. 9. An interest of 25% per annum on the total judgment sum as may be awarded by this court from the date of judgment until same is finally liquidated. 10. Cost of maintaining this suit as may be assessed by the court. Only reliefs 1, 2, 3, 4, and 10 are prayed for in the amended statement of facts. Case of the claimant is that he was employed by the defendants in 1993. His employment was confirmed and he enjoyed promotions, and then up to 2008 as higher executive officer. And then that sometimes in 2010, he was accused baselessly of criminal conspiracy, diversion of checks, draft payment, and forgery of FIRS, VAT, and revenue receipts. He was charged to court along with 3 others. While the proceedings were going on, the 3 others were dropped. And then while the proceedings were still going on, the criminal trial was still going on, the defendant set up a disciplinary committee, sat in his absence, and dismissed him. After that, eventually the Federal High Court delivered judgment in his favor, discharging and acquitting him. The defense of the defendant, on the other hand, in summary, did not deny all those facts, but justified it acting the way it acted on the ground that the trial proceedings at the Federal High Court was delaying inordinately and that they could not wait. So they did what they did. Now, learned counsel submitted final written addresses. All their arguments resolve around whether the claimant proved his case and whether the defendants could act the way they acted, and in any event, whether the defendants had the jurisdiction to try and find the claimant guilty of a criminal allegation. Court's decision. A brief summary of the case before the court is that the claimant was employed on 30th November 1993. He was accused of criminal conspiracy, diversion of check/draft, payment, and forgery of FIRS, VAT, and revenue receipts. He was charged on the said allegation at the Federal High Court. He was consequently suspended from work with effect from 1st August 2010, pending the outcome of the court processes. While the court processes were still ongoing, the defendant set up a disciplinary committee, tried the claimant in his absence, and dismissed him. The Federal High Court eventually discharged and acquitted the claimant. The defendants have appealed the decision. The claimant now claims for reinstatement and payment of his emoluments from the date of his suspension. The issues for determination accordingly are as follows. 1. Whether the claimant has established before this honorable court that his employment enjoys statutory flavor. 2. Whether the defendants can lawfully set up officers' disciplinary committee to inquire, investigate, and determine a criminal allegation that is already pending before the Federal High Court, as done in the instant case. 3. Whether the claimant, by the judgment of the Federal High Court, discharging and acquitting him of all the allegations, is not entitled to all or any of the reliefs as contained in the general form of complaint. Ruling on admissibility of exhibits marked tendered. Before considering the merit of the case, it is pertinent to rule on some documents tendered by the claimant and objected to by the defendant, which the court marked as tendered. At the hearing, the claimant subpoenaed a private witness, Judge Oshe, CW1, an auditor with Olu Akanbi & Co., an accounting firm. CW1 tendered in evidence a document titled Presentation of Salaries and Allowances and dated 30 January 2022, signed by himself as manager of Olu Akanbi & Co., and addressed to the claimant. The defendant also objected to 7 other documents which were marked as exhibits OBJ 6, OBJ 7, OBJ 8, OBJ 9, OBJ 10, OBJ 11, and OBJ 12, all tendered and reserved reasons for final written address and ruling reserved till judgment. The defendant also objected to these documents and reserved his reasons for final address, but did not address the objection in his final written address. The objection is deemed abandoned. However, having reserved ruling, the court must rule one way or the other. The first thing to observe about this document is that this case was filed on 15th April 2019, while this document was made on 30th January 2019 during the pendency of this suit. This alone qualifies the document as one made in contemplation of proceedings contrary to Section 91(3) of the Evidence Act 2011 and so inadmissible. See Musa and another versus Abdullahi and others, citation fully supplied, where the court held truly, by virtue of Section 91(3), any document made in anticipation of a suit is inadmissible. There is another court holding. You are holding another court?
No, my lord.
No, it's inside the courtroom here. Some
Okay.
people are holding another court session. Furthermore, I have scrutinized the claimant's 35-paragraph statement of facts and did not see where this document is pleaded. This also renders the document inadmissible. Accordingly, the document tendered and marked subpoena 1 is inadmissible and same is marked rejected. On exhibits OBJ 6 to OBJ 12, all tendered, the defendant having abandoned his objection, the court finds no reason on the face of the documents to reject them. More so, these documents are pleaded. The documents exhibit OBJ 1, 7, OBJ 6, 7, 8, 9, 10, and 11, all tendered are accordingly admitted and so marked without the word tendered. Merits of the case. Issue 1, whether the claimant has established before this honorable court that his employment enjoys statutory flavor. The claimant in his relief 1 sought for a declaration that his employment enjoys statutory flavor and thereby put the status of his employment in issue. So he has a duty to show the court either by evidence or legal argument that his employment enjoys statutory flavor. Whether or not the employment of a claimant enjoys statutory flavor is more of a question of law than a fact, and so issues need not be joined. The claimant sought for a declaration that the employer enjoys statutory flavor. The defendant is entitled to rebut it by way of legal arguments in the final written address. It is observed that besides relief 1, the claimant made no attempt in his pleadings and deposition to say anything about the status of his employment. Furthermore, the learned claimant counsel appeared to chide away from canvassing legal arguments to show how the employment of the claimant is statutorily flavored. Counsel simplistically submitted that issues were not joined on the status of the claimant employment. It is unfortunate that the claimant letter of appointment is bereft of information which could help the court in determining the status of his employment. However, the defendant is a federal government agency and the claimant's promotion letter exhibit OBT1 conveys approval of the Federal Civil Service Commission for the claimant's promotion to grade level 8. This is a good ground to infer that the claimant's employment was by or with the authority of the Federal Civil Service Commission and is regulated by the public service rules and thus statutorily protected. See Okomu versus Iserienren. I forgive my inability to pronounce the name. 2001 3SC is also reported at 140, is also reported at 2001 Federation Video Report Part 45 670, where the Supreme Court Part Y for JSC held as follows. In order to be able to reach any conclusion that the said rules 04102 Federal Civil Service Rules applies to the plaintiff, it must be shown, in my view, that he was a public officer employed by or with the authority of the Federal Service Commission. Issue 1 is accordingly resolved in favor of the claimant and it is hereby declared that the claimant employment enjoys statutory flavor and so is statutorily protected. Issue 2. Issue 2 is whether the defendants can lawfully set up officers' disciplinary committee to inquire, investigate, and determine a criminal allegation that is already pending before the Federal High Court as done in the instant case. It is not in dispute that the claimant was suspended pending outcome of the court processes which is the criminal trial, and that while the criminal trial was still pending, the defendant set up a disciplinary committee to try the claimant, and on the basis of which the claimant appointment was terminated. The only question now is the propriety or the justification of the defendant's action. The defendant offered no justification for his act of trying and terminating the appointment of the claimant for an offense for which a criminal trial was already pending in court. The defendants were more concerned with the argument that they followed due process. The Court of Appeal for Omoloye JCA in Board of Management of FMC Makodi versus Kwembe, citation supplied, my Lord held. What is more, it is not an immutable principle of law that where the act of misconduct by an employee, which also amounts to a criminal offense, the criminal offense must first be prosecuted before the employer can exercise his power of summary dismissal of the employee. Cited the case of Nigeria Oil Mills versus Taura and Arinze versus FB Nigeria Limited. This authority is talking about a situation where the act of misconduct by an employee also amounts to a criminal offense. This finds support in the Public Service Rules 030411, which is under Chapter 3 on discipline, and particularly under Section 4, titled Serious Misconduct. Rule 030411 provides as follows, and I quote, "Nothing shall prevent disciplinary action being taken or continued against an officer, whether or not, one, criminal proceedings have been instituted with respect to such a person in a court of law in Nigeria or elsewhere, or are about to be instituted or are contemplated, or two, the grounds upon which any criminal charge are based or are to be based are substantially the same upon which the disciplinary proceedings were or are to be instituted. Three, an officer acquitted from a criminal charge shall not be penalized for any charge of which he or she has been acquitted, but nothing in this rule shall prevent him or her being dismissed or otherwise punished on any other charges arising out of his or her conduct in the matter, provided that those charges do not raise substantially the same issue as those of which he or she has been acquitted. If the Commission thinks fit, the usual procedure may be followed for the purpose. This rule is therefore only applicable where the act of misconduct by an employee also amounts to a criminal offense. It does not apply where the act complained of is purely and only criminal in nature. The entire Public Service Rules has only Chapter 3 on discipline, and the entire Chapter 3 does not in any way deal with purely criminal acts. Chapter 3 of the Public Service Rule is divided into 6 sections as follows. Section 1, Introduction. Section 2, General Inefficiency. Section 3, Misconduct. Section 4, Serious Misconduct. Section 5, Conduct prejudicial to the security of the state. Section 6, Retirement in public interest. The one and only implication of this is that the disciplinary powers conferred on whoever by the Public Service Rule does not extend to a purely criminal act. Where the act of an employee complained of is purely criminal, the rule is that where there is an allegation of criminal wrong against a person, particularly where the criminal allegation is denied, the jurisdiction to determine the allegation is vested in the courts, and the exercise of such jurisdiction cannot be usurped by any administrative tribunal, cited are the cases of Doctor and Civil Service Commission, Plateau State, and other citation is there to J.I. of custody and Mr. Ibrahim Jibril and the military administrator of Kwara State citation supplied. In the circumstances of this case, what is applicable is Rule 030404 of the Public Service Rules, which provides as follows, and I quote, when a serious case that may lead to dismissal has been instituted against an officer, the permanent secretary stroke head of extraministerial office may interdict him or her on not more than half pay pending the determination of the case. 2. Recommendations in the commission for interdiction shall be made only if it is against the public interest that the officer should continue to perform any of the duties of his or her rank, when the charge against him or her is such that the continued performance of his or her present duties is against the public interest or prejudicial to the investigation of the charge against him or her. Consideration shall be given to putting him or her on alternative duties. Interdiction shall only be resorted to when this is not possible. 3. When an officer is interdicted, he or she shall cease to report for duty. In the letter referring the officer of informing the officer of his or her interdiction, it shall be indicated that the portion of emolument he or she is to receive while on interdiction shall be 50% of his or her emoluments. 4. If proceedings under Rule 030441 reveal that he or she is not guilty of the charge made against him or her, the officer shall immediately be reinstated and shall receive his full amount of the full amount of his or her emolument denied him or her while he or she was interdicted. 4. 5. If the officer is found guilty but is not dismissed, he or she may be refunded such portion of the emolument denied him or her as the commission may determine. Accordingly, the defendant lacks the virus to conduct a disciplinary proceedings, find the claimant guilty, and dismiss him for a criminal allegation for which the claimant was still being prosecuted at the Federal High Court. More so, in the circumstance of this case, it is not the contention or evidence of the defendant that the offense of the claimant also amounted to misconduct and that the claimant was disciplined for the misconduct. The defendant had already activated and started complying with the provisions of the Public Service Rules. It has no power to feel the prosecution was taking too long and to decide to help itself. The issuance of a letter inviting the claimant to appear before a disciplinary panel of the defendant for the same offenses or allegations for which the claimant was facing criminal trial at the Federal High Court, and all actions taken subsequent thereto with respect to the employment of the claimant cannot stand, and same is hereby set aside. Issue 3. Whether the claimant, by the judgment of the Federal High Court, discharging and acquitting him of all the allegations, is not entitled to any or all the reliefs as contained in the general form of complaint. By Rule 030442 of the Public Service Rule, if proceedings under Rule 030441 reveal that he or she is not guilty of the charge made against him or her, the officer shall immediately be reinstated and shall receive the full amount of his or her emoluments denied him or her while he or she was interdicted. It is also the uncontradicted case of the defendants that it appealed the decision of the Federal High Court. This means that the trial of the claimant is still ongoing as trial includes the appeal. In the circumstance, by Rule 03040442 of the PSR, the claimant is entitled to be reinstated and to receive the full amount of his emoluments denied him while he was interdicted. However, the claimant cannot be reinstated until the final decision from the Court of Appeal. Similarly, the court cannot order payment of any withheld payments to the claimant in view of the decision of this court in suit number NICN/ABJ/48/2014 between the parties which has not been appealed. In the initial processes filed on 15th April 2019, the claimant prayed for 9 reliefs numbered 1 to 10 in both the complaint and the statement of facts. However, the claimant claimed for 10 reliefs in his amended complaint numbered 1 to 10 and reproduced above, but in the amended statement of facts, he reproduced reliefs 1 to 4 and 10, making 5 reliefs, omitting reliefs 5 to 9. The defendant counsel in his final written address reproduced the 10 claims in the complaint as the reliefs being sought before the court. Now, the position of the law is that the reliefs in the statement of claim or statement of facts supersede the reliefs in the writ of summons or complaint. See Guda and others versus Kita citations supplied, Onyero and Wadike citations supplied, Chief J. Olahan and Chief La Joyeton and other citations supplied, and Stowe and another versus Ben Stowe and another citation supplied, where the Apex Court parodies rival JSC held. The correct practice is to conclude the plaintiff's pleadings by making a claim on each item on the writ of summons. The statement of claim supersedes the writ of summons, and if reliefs claimed are only in the writ of summons and not in the statement of claim, then the statement of claim no longer supersedes the writ of summons and the reliefs claimed are abandoned. Following the above authorities, the claimant's reliefs 4, 5, 6, 7, 8, and 9 on the complaint are deemed abandoned and will not be considered. Court order. For the avoidance of doubt, the claim of the claimant succeeds, and the court hereby declares as follows. 1. A declaration that the defendant's appointment enjoys statutory flavor, and therefore the claimant's appointment cannot be determined without following due process of law. 2. A declaration that the defendant did not follow the due process of law before purporting to terminate the appointment of the claimant as conveyed in the letter of termination of appointment dated 5th February 2019 with effective date of 24 January 2019, and consequently, the purported termination is ultra vires, null, void, and of no effect whatsoever. 3. A declaration that the purported letter of invitation to a meeting of officers committee dated 19th October 2018 served on the claimant during the pendency of criminal trial was maliciously and oppressively issued without justification against the claimant by the defendants, hence null, void, and of no effect whatsoever. 4. A declaration holding another court session. 4. A declaration that the purported letter of termination of appointment dated 5th February 2019 served on the claimant's erstwhile counsel during the pendency of a criminal trial was maliciously and oppressively issued without justification against the claimant by the defendant, hence null, void, and of no effect. Each party to bear its cost. This is the judgment of the court and it is entered accordingly.
As God pleases.
Yes, has defendant counsel appeared?
Yes, I can see. Yes.
Yes, my lord, yes, very well.
Please,
I
your
sincerely
appearance.
apologize. I had the ID that was sent to me was 40. So
Yes,
I
your
had to call
appearance.
for them to resend the ID. Yes,
Just
UI
announce your
Okuri, my lord.
appearance. You are.
Yes, UI Okuri.
Yes, what do you say
Humble
to the
appearance.
judgment?
My lord, we are much
Osteni.
grateful. We
Yes,
thank
my
you so much
lord.
for your
My
time.
lord. My lord, we are grateful for the well-considered judgments just delivered.
Akure.
Yes, my lord, we are indeed very, very grateful. Thank you so much for your time and your patience with us. The Lord will continue to strengthen you, sir.
Thank you.
Much
The
obliged.
judgment, the clean copy will be ready for collection by tomorrow.
As God pleases. We are most grateful, my lord.
Much obliged. Thank you so much, sir.
You're welcome.
Thank you, sir.
Vanessa. Well, gentlemen, this is the end of the Zoom proceedings.